The story comes to us from the sfchronicle.com. It's from the San Francisco Chronicle, but it deals with California. This is the story we've been waiting for. This is the one that all you people in California, SGV News and Pedro Libre audits and Riverside County Accountability and South Central audits and UB Chillin. I can't think of your name. Deep voice guy that goes, yeah, right. Lawless, right? Lawless? I don't know. Sorry. But I am subscribed to you. At any rate, what are you talking about, dude? I'm talking about all the people I named and more can sue law enforcement in California if you feel your rights have been violated. You say, well, you already could have sued them. Nah, qualified immunity would pretty much protect the cops and shield them. They hide behind that qualified immunity. Guess what? California has busted it down, just like the Berlin Wall. The state Supreme Court on Thursday broadened Californians' right to seek damages for abusive conduct by police, overturning decades of rulings that shielded police and the agencies that employed them from liability for any actions officers took during investigations. So basically, if they went overboard, now they can be sued. In the 7-0 ruling, Justice Leandra Kruger said state law does not provide a sweeping immunity for any and all acts police officers may perform within the scope of their employment. The court reinstated a lawsuit by a woman whose husband's body, after he had been fatally shot by a gunman, was left naked near the couple's home for 8 hours by Riverside County Sheriff's deputies who were searching for the shooter. Lower courts had dismissed Dora Leon's suit because the officers were investigating a crime, though there was no prosecution because the gunman killed himself. The justices also rejected the reasoning of 12 state appeals court rulings since 1982 that had interpreted a California law to bar damage claims against officers and their government employers for police conduct during actual or potential criminal investigations. So basically, the justices are saying, look, now you can file a lawsuit for damages. Where before it was barred, the lawsuits were barred because of that QI. But the leading case also from Riverside County was titled Amy Lou R., the name of a 15-year-old girl who had been raped by a man who raped and killed her friend. Officers said she was not cooperating adequately in the investigation, began telling her friends and family that she was lying and had actually taken part in the killing, even though she was a victim. Now, you can't come back and sue them, right? California says, let's change that. She sued and won $325,000 in damages, but an appeals court overturned the verdict and dismissed the lawsuit in 1994 because the officers had been conducting an investigation. Those damages will not be reinstated now because the case is over, but the appellate ruling will no longer be a binding precedent for lower courts. So in other words, if courts say, no, the officers were conducting an investigation, the state Supreme Court of California says now, no, that's not a precedent. You can still be sued for damages. Don't matter if you were conducting an investigation. If you F up, you pay up. This is the time, if there ever was one, for you guys to get out and start recording the police in their interactions. This is the time. Because now people can use your footage to sue cops for damages when they violate their rights. Well, before, we're conducting an investigation. And the Supreme Court says, or the state Supreme Court says, no, that doesn't matter. F around and find out. Richard Antognini, a lawyer for Dora Leon, says no matter how wrongful or malicious their conduct was, it was impossible to sue. He's talking about cops. He said he did not know why the state's higher court had not taken up the issue earlier, but that if the court had endorsed the appellate rulings, it would have undermined all the civil rights statutes the California legislature passed over decades. So if the California State Supreme Court had accepted the appellate court rulings, he's saying that all the civil rights statutes in California would be undermined. But instead, the California State Supreme Court rejected the appellate court's rulings and said, no, 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 you can sue. You can sue. Yeah. Now, attorney Leslie Zador, who filed arguments urging the court to overrule the Amy Lou R decision and reinstate Leon's case and others, said there's no more investigative immunity. Zador represents the parents of a youth fatally run over by a highway patrol officer who the lawyer said was speeding down a freeway without activating his warning lights or siren. A court dismissed the parents' lawsuit because the officer was conducting an investigation. But now the California State Supreme Court says if that happens again, he can be sued, and don't matter if he's investigating or not. We reject that. A lawyer for Riverside County cannot be reached for comment. The cases involve a 1963 state law that shields government employees in California for damages for any harm caused by instituting or prosecuting any judicial or administrative proceeding, even if an employee acted maliciously and without probable cause. Basically, cops could do whatever the hell they want and sue me. Who cares, man? I got qualified immunity. Not anymore. California State Supreme Court said, we're pulling that down. Like a prom queen's dress. Though state courts have issued varying interpretations of the law, most rulings in recent decades have relied on the Amy Lou R decision to reject damage claims against police and their employees as well as prosecutors. But the court said Thursday that the law was intended only to protect those involved in prosecutions, including allegedly malicious prosecution, and not to shield police. So extending immunity to officers investigating potential criminal charges ignores the simple reality that investigations need not and often do not lead to the institution or prosecution of any proceedings, a fact that ought to serve as a tip-off. And the two things that are not the same, Kruger wrote. So she's saying if you're investigating and you screw up or you maliciously violate someone's rights, you could have been like, you can't sue me. I was investigating. But Kruger and the other 6 judges have said, no, that doesn't matter anymore. Now you're liable. She said the deputies who left Jose Leon's body, that's the Dora Leon case, unclothed for 8 hours after his shooting, were engaged in the investigation of a potential crime unconnected to the filing of any charges and were not shielded from his wife's lawsuit, meaning she can sue, she can collect. That case, by the way, is Leon versus County of Riverside, if you want to look it up. So basically, guys, that's a win-win in California. Get out there, record the cops, because now if they violate someone's rights, if it's malicious, or even if it's just because they don't know their job, they can be sued and be held liable for damages. Doesn't matter if they're conducting an investigation. Cop screws up, cop pays up. That's how it is now in California. Colorado, I believe, also removed qualified immunity from lawsuits that their officers can also be liable for damages. It's coming down, guys. It's coming down. That kingdom that cops live in called qualified immunity is coming down brick by brick, by mother humming brick. States are opening their eyes and going, whoa, you know what? These cops need to be held accountable. For real. It's coming.